Hello, I'm John Dickerson. Thank you for joining us. All three branches of government are colliding. At roughly 5 p.m. Eastern, the Supreme Court announced that for the second time this year, it has agreed to hear a case involving former President Donald Trump, a case that could directly influence the 2024 presidential election. At issue, whether a president of the United States has absolute immunity from potential crimes committed against their country. Trump is currently indicted for conspiracy to defraud the U.S. and conspiracy to obstruct an official proceeding in connection with the 2020 election, which his supporters tried to overturn by attacking Congress as it met to certify the vote in the U.S. Capitol. We have team coverage of the news, including analysis from our chief legal correspondent, Jan Crawford, and CBS News legal analyst, Jessica Levinson. But we start with our congressional correspondent, Scott MacFarlane, who's on Capitol Hill.
The Supreme Court set the stage for landmark arguments in 2 months. Its order tonight says it will hear arguments the week of April 22nd into whether, and if so, to what extent, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office.
We've never been here before. We've never had a president who was criminally charged. And they're asking a fairly straightforward question. Does a president enjoy absolute immunity from criminal prosecution based on official acts?
The decision delays indefinitely the trial involving Trump's efforts to overturn the 2020 election. With a Supreme Court decision not expected until May or June, it could endanger chances to hold the trial here in Washington before the 2024 election.
As a president, you have to have immunity.
Trump faces 4 felony charges, including conspiracy and obstruction for allegedly plotting a scheme to defy voters and hold on to power.
We're going to walk down to the Capitol.
And special counsel Jack Smith has argued Trump used the riotous attack on the Capitol by his supporters as a further tool to do so.
The central cause of January 6th was one man, Donald Trump. None of this would have happened without him.
His appeal claims he's immune from prosecution because the alleged acts were official acts he took while president. It was rejected promptly by Judge Tanya Chutkin, who said presidents don't have get-out-of-jail-free cards. Then it was rejected again this month by a Washington, D.C. appeals court.
And Scott MacFarlane joins me now, along with CBS News chief legal correspondent Jan Crawford. Scott, I want to start with you. The trial, Judge Chutkin has the trial on pause. It will stay on pause now. How could this decision, the time it all takes for the argument and all the rest, affect the trial, and when could the date be? I mean, could essentially this trial be going on basically right up until Election Day?
Well, the clock is ticking so loud, John, you can hear it off the marble walls in the courthouse. If the Supreme Court returns a prompt decision and gets this back to Judge Tanya Chutkin, she's got to get this thing on her calendar, and she has other things on her calendar. She's a functioning federal judge. I've looked at her calendars for May and June. There are hearings. There are things going on, but you got to clear a lot of space for a Trump criminal trial. This thing will take at least a month, maybe 2 months, and has an enormous bandwidth and footprint. So scheduling becomes very difficult, and I think ultimately it's going to get particularly close to things like conventions, debates, and election, which raises a different question. Does the special counsel in the Department of Justice want to hold the trial so close to those things?
Jan, are you surprised by the court's decision to hear this case, and anything about the timing that seemed interesting to you?
Well, I mean, I think the court had to take up this case under their own rules, the Supreme Court's rules, when they're trying to decide how you grant cases. When you have an issue of tremendous constitutional significance that's never been decided, those are the exact cases the Supreme Court is supposed to take up under its rules. So that's what they're doing. And I think with that timeline, as Scott outlined, it makes a lot of sense. Jack Smith wanted arguments in March. They gave it a little longer just to really thoroughly consider this weighty issue. But that still provides they can have a decision by the end of June, which again is what Jack Smith in his court papers asked for, a decision in this case by the end of June. So that means according to Jack Smith's suggestions in his filings, that he's okay with this timeline. The question, though, is would it have made any difference anyway? Because a separate case, there is a third case that involves Donald Trump and whether or not the obstruction charges that have been filed against him are even legit. The court's got a separate case it's hearing arguments on April 16th that involves some other January 6 defendants charged with obstruction of justice. That is half of the case against Donald Trump. So I don't even know if it was clear that this case would have started before then anyway. So I don't think that it's going to necessarily add that much time. And the court had this obligation, I think, under its own rules to take it up. And
quickly, Jan, Justice Roberts cares a great deal. They all do probably, but he particularly, Chief Justice does, about the court's role in an American democracy. How complicated is this for him, or is it not as complicated as some might think?
I don't think it's that complicated because this is a real moment for the court to show they're above politics. I think Donald Trump is going to win that case that's still outstanding right now on whether or not states can exclude him as a, quote, insurrectionist from their presidential ballots. I expect a decision in that case in the next week or two at some point soon. We're waiting on that one. And I think the justices in this case are going to look really skeptically at arguments Trump is making, which are sweeping. I mean, that he can't be prosecuted at all for criminal acts while he was president. So I think that this could be a moment where the court can show potentially unanimously that they're above politics. And I think the way they've handled this case so far, with the way they've set the timeline, suggests that maybe they may be headed in that direction, John.
And Scott, quickly, the reason the timeline might matter if it does go on longer is what would Donald Trump, if he won, what could he do with this case if he were elected president again?
Yeah, can absolutely shut it down. The federal prosecutions could be shut down by a future president, but the dates just jump out at me. This trial was supposed to begin Monday, John. April 22nd, that's the week we expected jury deliberations. And ultimately, for a good sense of things, Judge Tanya Chutkan, she was in court when this ruling came down on another January 6 case, emphasizing the importance of these cases to ensure there's a stronger democracy moving forward.
Scott MacFarlane and Jan Crawford, thank you both very much. In a statement, former President Trump suggested not having presidential immunity would impede future commanders-in-chief from doing their job. He said, quote, without presidential immunity, presidents will always be concerned and even paralyzed by the prospect of wrongful prosecution and retaliation after they leave office. CBS News legal contributor and Loyola Law School professor Jessica Levinson joins us now. Jessica, thank you, as always. Would you just start by addressing the former president's claim that absolute immunity is needed or presidents will be prosecuted out of office?
Well, I think that we've seen that history indicates that's actually not a problem. And I know that the former president has made this argument in a number of different cases, meaning if they can do this to me, then they're just going to start doing this going forward. But President Trump was not our first president. He was not our second president. We've had a lot of presidents, and this is the first time that we've been here before where we have a president who is facing criminal prosecution. Now, I'm not particularly concerned about the slippery slope that the former president is talking about. What I would be more concerned about, frankly, is a decision from the court that indicates that, in fact, one person is above the law, that once you get a certain job, and that job being former president of the United States, that you can't be touched for any official acts that you took while in office. And if you read the D.C. Circuit's opinion, what they really say is the separation of powers collapses if we say that presidents enjoy absolute immunity based on official actions that they took.
And by saying the separation of power collapses, what they're saying is that the system of government in which you have three branches with power that they each and all pull like the pieces in a watch, that if you take away the ability to go after a president, then there's no counterbalance against presidential power, which means if they have all that power, it can be abused without anybody checking it.
I'm pretty sure you said it better than I will in less than 2 hours in class when I teach this case, but that's exactly right. The idea that you can't take one of the poles away from the stool, and the idea also that, well, there were two things that the former president brought up before the D.C. Circuit, and they both kind of collapsed. The first was the idea that before you are tried, then you need to be impeached in the House and convicted in the Senate. And during the oral arguments in the DC Circuit case, his attorneys were asked, but what if you commit a crime and then resign the next day? Does that really mean, since you can't be impeached, that you could never be criminally charged? After you acknowledge then that you could be criminally charged, even if it's after an impeachment, then the entire argument that you can't have one branch looking at the head of another branch, the executive branch, that really does collapse for all of the reasons that you just talked about.
What does it mean that the court decided to take this up? In other words, does it mean that they found some merit in his argument enough to at least consider it and think it through? Does it preclude a 9-0? What exactly, how should people understand what level of buying his argument that the court took by taking this up?
I think this means exactly what Jan Crawford said it means, which is these are the types of cases that the Supreme Court takes up. This is a case that I'm going to be teaching in class for a long time, and I teach Supreme Court cases because I teach cases about big constitutional questions that are oftentimes matters of first impression. And that's exactly what this case is. As Jan laid out very quickly, this is one of those cases where under the Supreme Court rules, they really should be the last word. Again, it's screaming out, I think, for the Supreme Court to say, here is our thinking when it comes to presidential immunity. And did the DC Circuit have a belt and suspenders opinion? Could that opinion have stood? Of course it could have. But again, I think the Supreme Court rules indicate they're the final word here on what the Constitution means, which is another way of saying, I don't think we should take this to mean, oh, you know what? The court took the case, so they want to correct something about what the DC Circuit said. I do not view it as that at all.
That's extremely helpful. Jessica Levinson, thank you, as always, for walking us through this. Very helpful.